Good morning, this is your Kelso Report for Tuesday, January 17th, and I'm your host, Clark Kelso. Well, we have three Ninth Circuit decisions to talk about today. First, in the area of immigration. In United States v. Arango, the Immigration and Naturalization Service brought an action against a naturalized citizen seeking to strip him of his citizenship on the ground that he had unlawfully procured his citizenship 20 years ago through misrepresentations and concealments. The defendant argued that he had entered into a cooperation agreement with the INS, which had permitted him to retain his status as a lawful permanent resident and to conclude his naturalization process in return for his cooperation in an investigation of a fraudulent marriage operation. The district court granted the INS's motion for summary judgment, finding that there was insufficient evidence of the cooperation agreement. Now, the Ninth Circuit reversed, holding that the district court had improperly weighed the evidence in the course of resolving the motion for summary judgment, something that you're not supposed to do. Our next case involves the area of constitutional law and takings. Now, you may recall that about a decade ago, there was a great deal of concern nationally about the power of local government to essentially take real property by imposing such onerous regulatory burdens on the property that its value decreased to near zero. In Oregon, the people enacted in 2004 an initiative to address the problem. It enacted a law requiring, quote, state and local governments to compensate private property owners for the reduction in the fair market value of their real property that results from any land use regulations of those governmental entities that restrict the use of the subject properties, close quote. Well, what seemed like a good populist idea at the time turned out to be pretty unworkable, and only 3 years later, the legislature put before the voters another initiative which essentially gutted the key provisions of the 2004 initiative. The question before the Ninth Circuit in Bowers v. Whitman was whether the second initiative was an unconstitutional taking of the rights granted by the first initiative. The panel held that none of the rights established by the first initiative were vested, so the amendment of the first initiative by the second did not unconstitutionally deprive anyone of rights in property. As the court noted, quote, there is no federal constitutional right to be free from changes in the land use laws, close quote. Our third case involves governmental immunity, qualified immunity. In Heydrich v. Hunter, the Ninth Circuit faced a class action brought on behalf of civilly committed persons who are confined at a state hospital as part of California's sexually violent predator program. The defendants are individual administrators and supervisors at the hospital, as well as certain other state officials. The plaintiffs sought damages in addition to declaratory and injunctive relief. So the issue of qualified immunity, of course, arose early in the case, and the District Court in the Ninth Circuit previously held that the defendants were not entitled to qualified immunity on most of the damage claims in the complaint. The Supreme Court granted review, vacated the Ninth Circuit's judgment, and remanded for reconsideration in light of Ashcroft v. Iqbal, a 2009 opinion. In last week's opinion, the Ninth Circuit finally held that in light of Iqbal, the defendants were entitled to qualified immunity from all of the damage claims because the plaintiffs had made only conclusory and bald allegations of wrongful conduct devoid of factual specifics. In other words, the plaintiffs pleaded insufficient facts to establish plausible claims against the defendants in their individual capacities, and the defendants then received the benefits of qualified immunity. Now we turn to the California Court of Appeal. Our first case is in the area of criminal law. One of the realities of a term-limited legislature in California, combined with our never-ending thirst for more crimes, is that we have created statutes that layer new crimes on top of existing crimes. The problem with this, of course, is that if you do it too casually, your new crime simply encompasses the foundation crimes as lesser-included offenses, and you really haven't done very much. Well, that's exactly what the 3rd District saw in People v. Dicer, where the defendant was convicted of, among other things, first-degree burglary, assault with intent to commit rape, and then assault with intent to commit rape during the commission of first-degree burglary. That's right, 3 separate charges, but it would appear the third charge is just a combination of the first 2. And in fact, when the court consulted the applicable penal code sections, it did indeed discover that the offense of assault with intent to commit rape during the commission of first-degree burglary could not occur without having a first-degree burglary and an assault with intent to commit rape. So the court held those 2 crimes were lesser-included offenses of the broader assault with intent to commit rape during the commission of first-degree burglary, and the conviction of the lesser offenses were reversed. Next, in the area of appellate procedure. Sometimes, in the effort to avoid opposing counsel's arguments, and at the same time to avoid aggravating the judge and further confusing matters, counsel may make a tactical decision to go with what the judge is inclined to do anyway, and not to offer a third preferred alternative. When counsel makes that tactical judgment, counsel is likely to find him or herself stuck with it. And that pretty fairly describes what happened to counsel in transport insurance versus TIG insurance, a lengthy, complex reinsurance dispute stretching back several decades. The key issue was whether the statute of limitations had run, and a critical jury instruction told the jury when the cause of action accrued and the statute started running. Well, in order to avoid the defendant's instruction, which was particularly bad, the plaintiff vigorously argued for the instruction the trial judge actually gave. The jury came back very quickly, however, with a finding against the plaintiff, holding that the statute had run. Now, putting aside the details of the jury instruction, factually, about 7 years separated a final letter from plaintiff demanding payment and the lawsuit. 7 years is a long time, irrespective of jury instructions. In any event, when plaintiff tried to appeal, the First District held that the doctrine of invited error applied, and the court affirmed the judgment without deciding on the merits whether the jury instruction was correct or not, thereby ending about 5 years of very expensive litigation without ever reaching the merits. Sometimes a counsel's tactical decision will do that to you. Well, that's it for today's Kelso Report. Have a great day in the law.